The Senate Judiciary Committee will come to order. There have been many hearings of this committee, and I've been honored to be part of them. I can't think of one more serious than this morning. We're dealing with a case of first impression before the Supreme Court and a decision which has long-lasting impact. We're dealing initially with the first criminal prosecution of a former president for action that he took during his presidency. The charges that were raised in the indictment were serious. False crimes of election fraud, fraudulent slates of electors, sham election crime, sham decision on criminal investigations, and trying to persuade the vice president to fraudulently change election returns. Serious charges brought before the court. The defense of the former president is that he is immune from prosecution. It's a question which has impact way beyond this particular case and this particular issue. Nearly 2 decades ago, then Judge John Roberts came before this committee for his confirmation hearing to be Chief Justice of the Supreme Court. I asked him about the limits of the president's power. In response, he told me under oath, quote, "No man is above the law, not the president and not the Congress." During his hearing, Roberts also repeatedly emphasized the limited role of a judge, famously comparing it to an umpire calling balls and strikes. But in 2024, Chief Justice Roberts authored the opinion in Trump versus the United States, a game-changing act of judicial fiat that puts all future presidents above the law, protecting them from criminal prosecution for abusing the authority given them for personal or political gain. In plain language, the court created 3 categories of varying degrees of presidential immunity. Core presidential actions, absolute immunity. Unofficial or private actions, no immunity. Actions within the outer perimeter of official acts, presumptively immune. The decision also protects any president by preventing prosecutors from using evidence related to conduct or acts that are immune to prosecute a president for acts not protected by immunity. The court also found that the president's motives, corrupt or not, may not be questioned. So even if a president is peddling access to his office, prosecutors would find it nearly impossible to bring charges against him. As Justice Amy Coney Barrett lamented, to make sense of charges alleging a quid pro quo, the jury must be allowed to hear both the quid and the quo. And in ruling that Donald Trump is, quote, absolutely immune from prosecution for alleged conduct involving his discussions with Justice Department officials, the court has stripped the Justice Department of its critical independence. Department of Justice may now stand as a weapon to be wielded by a corrupt president against his political opponents. As the committee demonstrated in our hearing known as Subverting Justice, our report about Trump pressuring the Department of Justice to subvert the 2020 election is not a far-fetched scenario. So what does all this mean? It means that any sitting president may hide behind their office for protection from prosecution for even the most egregious forms of wrongdoing. It means effectively condoning Richard Nixon's claim that, quote, when the president does it, that means it's not illegal. In fact, most of the conduct at the heart of Nixon's Watergate scandal, the obstruction of justice, wiretapping, cover-up, and the misuse of government agencies could be described as official actions that would be presumptively immune under this court decision. The Roberts Court judicial activism has also left us with limited options when dealing with delusional or corrupt executive. During the second Trump impeachment trial, the Senate Republican leader stated, and I quote, "We have a criminal justice system in this country. We have civil litigation, and former presidents are not immune from being accountable by either one." That was a quote from the Senate Republican leader. But this is no longer the case, because the Trump versus the United States ruling demolished our justice system's ability to hold any president accountable for abuses of power. Obstructing a federal criminal investigation of your campaign by firing your attorney general, allowed. Steering foreign governments to your family hotels and resorts in exchange for access to the White House, presumptively immune, and your motive cannot be questioned. Contrary to the Chief Justice's supposed goal of preventing political retribution through prosecution, he has heightened the chances of future conflict between the political branches. If faced with a corrupt presidency to meet the demands of the public and the Constitution, Congress will have to assert its power, from appropriations to oversight to legislation. The Supreme Court has made it nearly impossible for the courts to hold a runaway president accountable. It will be left to the American people and Congress to try to hold the line. Because, as Justice Sotomayor noted in her dissent, the president is now a king above the law. And with that, I turn to the ranking member Graham for his opening statement.
Thank you very much, Ms. Chairman. I don't know where we're going to hit bottom, but I hope we're close. This hearing is designed to continue an attack on the court because you don't like their rulings. The effort to delegitimize the Roberts Court seems to be unending. The rhetoric around this has led to a man being arrested outside Justice Kavanaugh's home with guns and ties. A few days ago, there was an effort to stop a man who wanted to kill and torture 6 members of the court. Senator Schumer famously went to the court and threatened Justice Kavanaugh and Gorsuch before the Dobbs decision. So the American people, I hope you understand what's going on here. My Democratic colleagues want to destroy this court. And if they get in charge of the House, the Senate, and the White House, virtually all of them has said they will expand the court from 9 to 13, or whatever number they want to pick, to dilute the conservative majority that's been formed over decades. Why? Because they want the court to be another extension of their liberal agenda. For decades, Democrats have enjoyed a court that would rule in their favor when they couldn't win at the ballot box, and that's come to an end. So their response is to destroy this court. I promise you it will not go unanswered. The attack on this decision is incredibly, well, I like all my colleagues on this side, is just really off base. This is not uncharted territory. The Supreme Court in Nixon versus Fitzgerald said that former presidents are immune from civil liability for official conduct. Now the question before the court, what status does the president have against criminal prosecutions? All of us, I think to a person, believe that what's going on against President Trump in New York and Georgia and other places is politically motivated legal garbage. That's what we think. We think Jack Smith's efforts are beyond the pale. They talk about insurrection, but he won't be charged with it. They've opened up Pandora's box. There'll be conservative prosecutors in states and counties probably taking up the challenge in the future, and that'll be bad for the presidency. What's going on here in America at this point in time, I think is bad for the presidency. Now, what did the court do? It issued a decision regarding the status of the president, and it said the following: absolute immunity for actions within his conclusive and preclusive constitutional authority, such as pardons. When the Constitution confers an authority on the president specifically, they have absolute immunity. If that weren't the case, it would be chaos. Could you prosecute a president for a pardon that you didn't like? No, because that's the authority granted to the president by the Constitution. The Constitution makes the president the commander-in-chief. Presumptive immunity for other official acts. Now, these are official acts not specifically granted by the authorities granted by the Constitution. The Blassingame versus Trump case, 2 liberal judges and 1 conservative judges talked about this. Official acts extend to the outer perimeter of the president's official responsibility. It covers actions so long as they're not manifestly or palpably beyond his authority. Basically, the court adopted that reasoning. And the third is there's no immunity for unofficial acts. Now, that to me is a logical approach to how you would handle presidential immunity regarding criminal prosecution. When the Constitution gives the authority to the president specifically, they have absolute immunity. When they're acting officially, and that has to be a factual determination, I would suppose, there's a presumption that can be wiped away, and there's no immunity for unofficial acts. That to me seems to be a reasoned approach to a problem. Before the court ruled, it was established that back in the 80s, civil liability protections for the office of the president. Now we have before us issue of criminal liability of the president. All you want is an outcome. You could care less about the law. I've seen this firsthand in this committee with Kavanaugh. You just wanted to tear him down and keep that slot open. That's the problem with liberalism from my point of view, is that you just want an outcome. If you can't get what you want, then the people who said no must be bad for the country. They must be, bad people. You want the court to get you outcomes. You really don't care how they get there. And that's dangerous. And we're going to fight you on this. And we're going to win the majority. And we'll have hearings about a lot of things you won't talk about. And we'll do some good work together. We've worked on protecting children from online predators, and we'll continue all that. But if we get in charge of this place, I promise you this attack on the court is going to stop. It will be over. You will have lost the ability to try to take an independent branch of government and degrade it because you don't like the outcomes. Justice Roberts is probably the smartest person I've ever met in my life. I think he's motivated by an allegiance to the law. He has a conservative bent, that's for darn sure, but that's okay. It's okay to have a liberal bent, as long as you're faithful to the law. I think he is. Matter of fact, I think he's one of the most decent people to have ever held the office of Chief Justice of the Supreme Court of the United States. At his very core, he's a decent man. And what are you accusing him of? Basically, creating a monarchy in our country. That's just shameful. Sotomayor and Kagan, I voted for both. I thought they were qualified. I think their dissents here are beyond the pale. Just out there, kind of wacko stuff. Politically motivated dissents, but I respect them both. I just don't agree with them here. So the bottom line is, this hearing is not about righting a wrong. This hearing is about a continued narrative of delegitimizing a court you don't like. So we'll see how this holds up over time.
Thank you, Senator Graham. Now I'd like to turn to Senator Whitehouse, Chair of the Courts Subcommittee. Thank him for his leadership on these issues and for working with the committee to organize this hearing. Senator Whitehouse.
Thanks very much, Chairman Durbin. There are several conclusions you can draw from this sorry episode. One is what laughably fake and disposable doctrines textualism and originalism are. Trump v. United States was manufactured out of thin air. Nothing textualist or originalist about it. Doctrines of convenience. Citizens United similarly had no originalist underpinnings. While we're at it, so much for case or controversy humility, or solving a split among the circuits. Instead, we get this grandiose partisan leap to a so-called decision for the ages. The Constitution does grant immunity. So the founders knew how to do that. They did not give immunity to presidents. The immunity granted in the Constitution was to legislators, to protect Congress against what the founders feared most, abuse of presidential power, like ordering false arrests to block our voting. Even then, legislative immunity accepted felony and treason. The Trump justices invented presidential immunity and then didn't even carve out treason. The first mention ever that a president can freely commit crimes comes from this court, just as we have our first ever criminal presidential candidate. Trump just offered a $1 billion quid pro quo to his fossil fuel donors. Bribes of officials are usually for official acts. Now the acts can't even be used as evidence. Treason, too, is usually most dangerous from the inside. A treasonous president using his official powers, collaborating with crooked appointees in his administration, whom he can pardon, could sell America out to foreign enemies. Whatever deals or concessions Trump may obtain from Vladimir Putin to sell out our Ukrainian allies, he can walk away with scot-free. The timing smells too. The Colorado insurrection case needed a quick decision to help Trump, and Trump got a quick decision. Quick decisions can happen. United States versus Nixon took 3 weeks. Bush v. Gore took 4 days. What would help Trump in this case was delay, and he got delay. And then he got this decision, creating yet more delay. Had the court intended to shelter the Republican nominee from unpleasant accountability before the election for criminal acts, it could hardly have done better. He got a slow-mo Bush v. Gore. Remember how we got this. The billionaire's scheme to capture the court, spending over $500 million doing it. The billionaire's secret gifts program to keep justices happy, showering a particular justice with millions of dollars in gifts. The billionaire funded flotillas of amici providing directions. The absence, uniquely in government, of any ethics process, not even fact-finding. Creepy right-wing billionaires worked for years through phony front groups and mischievous minions like Leonard Leo to acquire the court that dark money built. The billionaires are reaping the rewards now of move after move towards oligarchy. Unlimited political money, secret political money, voter suppression, gerrymandering, squelched political corruption prosecutions, and now allowing a billionaire's stooge president to use his powers criminally with impunity to help the creepy billionaires. It is starting to look less and less like America. Thank you, Chairman.
Thank you, Senator Whitehouse. I now turn to Senator Kennedy, ranking member of the Court Subcommittee, for his opening statement. Senator Kennedy.
Thank you, Mr. Chairman, and thanks to all our panelists today.
Thanks.
With respect, I don't agree with the way our esteemed chairman has characterized this hearing today. He refers to the Trump v. U.S. opinion, a 6-3 opinion, by the way, of the United States Supreme Court, as, quote, when the president does it, that means it's not illegal, end quote. I do not believe that that is a fair reading of the opinion. And frankly, I don't understand how anyone who's read the opinion, which I reread this weekend, it's only about 90 or so pages, could reach that conclusion. I know many people look at this opinion, and it is their right. This is America. We can believe what we want. I know many people look at this opinion through the lens of former President Trump and whether they like him or dislike him. The court, in its opinion, was very careful to point out that its opinion, more than anything else, was about the institution of the presidency. The institution of the presidency. The opinion is not just about the litigants in front of the court. It's about future presidents and future Americas. That's point one. Point two. It is inaccurate to say, under Trump v. U.S., that a president of the United States has absolute immunity to do anything that he or she wants. That's just not accurate. For example, the court is very clear in saying that a president does not have criminal immunity, including but not limited to a former president, for unofficial private acts. That's clear. I don't see how anybody can argue with that. Number two, the court does say that a president, whoever that president might be, does have absolute immunity for acts performed pursuant to his or her core responsibilities. Responsibilities given exclusively to a president by virtue of the Constitution. But there's a third category, which I would suggest will include most acts by a president. Those are acts taken pursuant to a president's authority, but authority that is also shared with the United States Congress. And the court does not say that a president cannot be prosecuted criminally for those acts. It does not. It does say that if a prosecutor, the prosecution, if it wants to prosecute a former president for that layer or category of acts, the burden of proof is on the prosecutor. Well, duh, the burden of proof is always on the prosecutor. You can call it presumptive immunity, but the burden of proof is always on the state. And the state has to prove that the president's prosecution for that middle layer of acts would not impinge, I think the words would pose no, quote, no danger of intrusion on the authority and function of the executive branch. Now that's hardly absolute immunity. And I'm looking forward to our panel today to enlighten us on this subject. Thank you, Mr. Chairman.
Thanks, Senator Kennedy. Today we welcome 5 witnesses. Our first witness is Philip Lacovara, who formerly served as Deputy Solicitor General of the United States for criminal and national security cases, Counsel to the Watergate Special Prosecutor, and President of the D.C. Bar. We also welcome Mary McCord, Executive Director of the Institute for Constitutional Advocacy and Protection at the prestigious Georgetown University Law Center. McCord was Acting Assistant Attorney General for National Security at the U.S. Department of Justice from 2016 to 2017, and Principal Deputy Assistant Attorney General for National Security from 2014 to 2016. Previously served as an Assistant U.S. Attorney. We're also joined by Dr. Timothy Naftali, a presidential historian and senior research scholar at Columbia. From 2007 to 2011, he directed the Richard Nixon Presidential Library and Museum, where he curated a nationally recognized nonpartisan permanent exhibit on Watergate and oversaw the release of 1.3 million pages of records. Ranking Member Graham, would you introduce the minority witnesses, please?
Thank you, Mr. Chairman. Our witnesses are Professor Jennifer Mascott. Did I get that right? Good. She's a professor and writes and teaches in the area of constitutional law at Catholic University's Columbia School of Law. She's been cited by the Supreme Court and published in the Stanford Law Review, among other publications. She previously served as the Deputy Assistant Attorney General in the Office of Legal Counsel. She's a former law clerk on the Supreme Court and the U.S. Court of Appeals for the D.C. Circuit. Our other witness is well known to this committee, former Attorney General Michael Mukasey. He served President Bush in that capacity from 2007 to 9. Prior to serving as Attorney General, he was United States District Court Judge in the Southern District of New York from 1987 to 2006. He served as an Assistant United States Attorney in the Southern District of New York. He works in private practice currently, and he most recently testified before the committee in May 2023 at the Supreme Court Ethics hearing. Welcome to both.
After we swear in the witnesses, they'll each have 5 minutes to provide an opening statement. Then each senator has 5 minutes to ask questions. Urge my colleagues to focus their questions on the topics of today's hearing. So we'll start with the witnesses standing to be sworn in, please. You affirm the testimony you're about to give, to believe the truth and the whole truth, nothing but the truth, so help you God.
I do.
Let the record reflect that the witnesses have answered in the affirmative. Thank you, Mr. I want to make sure I pronounce your name correctly. Lacovara?
Exactly, Senator.
Good. You may proceed.
Thank you, Senator, and members of the committee. I want to express my appreciation for the opportunity to appear today, and I want to emphasize at the outset that having served before the Supreme Court for almost 60 years, I have no interest in attacking the court as an institution. Rather, what I'm trying to suggest is that the court, in this decision at least, has brought criticism on itself. The court has always been subject to criticism, sometimes fair and sometimes unfair. It was criticized for the Dred Scott decision, for Plessy against Ferguson, for the Korematsu decision. All of those decisions, I think, have been repudiated by history, although they were rendered by majorities of the court. So the issue is not, is the court above attack on the merits of its decisions? The issue is, as I think you understand, is the decision that's under discussion today one that deserves acquiescence or not? And my submission is that it does not. I explained in my prepared statement that the decision is profoundly wrong and it is profoundly dangerous. It's profoundly wrong for several reasons. Notably, the court did not find any textual support for the decision. Indeed, the text points exactly the opposite. The court could not find an apt precedent in support of the decision. The only reliance the court could come up with, as Senator Graham mentioned, was a decision by a 5-4 court to grant civil immunity from private damage suits. Seems to me pretty obvious to any lawyers, even not constitutional lawyers, that the difference between immunizing a president from prospective liability to private citizens suing about official actions is fundamentally different from immunizing a president from culpability for committing crimes brought for violation of the same public interest statutes that apply to everyone else. The court could not rely on any historical practice in favor of criminal immunity. In fact, the practice is exactly the opposite. I know from my own experience in the Watergate affair that President Nixon was under active criminal investigation for his role in the cover-up. President Clinton was, President Reagan was. At no time before 2024 did any serious lawyer, nor did any of those presidents, claim that there was any kind of immunity from criminal exposure for crimes committed in office, including crimes committed allegedly in the performance of official function. The only issue that was debated during the Nixon period was whether the president could be indicted while still in office. Everyone, including President Nixon and President Ford, in granting a pardon, concluded that the president could be indicted for official acts after he left office. Constitutional text points in that same direction. The impeachment clause says that any person, including the president, whether or not impeached, is liable for indictment, prosecution, and punishment. And that necessarily includes official acts, because the only offenses for which a person may, including the president, may be impeached are official acts: bribery, treason, and what are described as other high crimes and misdemeanors. Those were understood when the Constitution was adopted to be maladministration or the improper and possibly criminal performance of official acts. That indeed is what the term bribery means: taking money to perform an official function. Text of the Constitution could not be clearer that a president is subject to indictment, trial, and punishment for that kind of improper, that is, illegal performance of an official function. My statement also goes into detail as to why this is a dangerous decision, not simply an erroneous one. It essentially licenses a president to abuse his power and to get away with it. Nothing could be further from the intent of the framers than to establish the kind of immunity that the king alone, the king who is the target of the abuses identified in the Declaration of Independence. And it seems to me to beggar any sense of the history of our country to treat the President of the United States as having the kind of immunity that no other person in this state, in this country, has to commit crimes and get away with it. Thank you, sir.
Thank you, sir. Professor Mascott.
Good morning, Chairman Durbin, Ranking Member Graham, and members of the committee. Thank you for inviting us here today to testify about presidential immunity and the Supreme Court's consideration this summer of the special counsel's criminal prosecution of President Biden's predecessor and now political rival. As a federal courts and constitutional law professor and former DOJ official, I'm grateful for the opportunity to speak about the opinion in Trump versus United States and help explain its scope. First, it's important to point out that since the court handed down its opinion, a number of public statements and commentary have significantly mischaracterized the opinion's holding and its scope. Some of those overstatements have made their way into some of the prepared testimony before the committee today. And before the Senate can evaluate the merits of the opinion, it's important to discuss what it actually held. So I look forward to summarizing the outlines of the opinion in this opening statement. The justices were compelled to take the case because the special counsel within the Biden administration and DOJ decided to prosecute President Biden's predecessor, and the prosecution has continued into this current political season, where we now have the unprecedented situations of a former president facing prosecution by the DOJ he once supervised, and a sitting president prosecuting his current rival. Second, the Supreme Court opinion actually continued and sustained this matter, remanding it to the lower courts. That remand occurred because the court held the opposite of what many commentators and even witnesses here today said it held. The court held that former presidents can be prosecuted for criminal unofficial acts. Both the former president's lawyers and the government agreed on this point as it relates to unofficial conduct. They simply disagreed about when and to what degree and for what kinds of acts a former president can face criminal prosecution. The court's opinion in Trump versus United States divides the categories of criminal prosecution and acts that are presumptively immune into three buckets. The first bucket is unofficial acts that are subject to criminal prosecution. Notably, as my prepared statement points out in more detail, the Office of Legal Counsel within the Clinton administration in 2000 published a formal executive branch opinion suggesting the opposite while a president remains in office. The 2000 Clinton-era opinion concluded that even unofficial acts could not be subject to prosecution while a president remained in office. Rather, a president would have to be impeached and then convicted by this body or have his presidential term otherwise conclude for a prosecutor to indict or charge a president criminally for even official acts under the Clinton-era opinion. That 2000 opinion emphasized the incompatibility between criminal prosecution and potential jury conviction and the role of a sitting president. Importantly, the Clinton-era opinion is clearly based on an underlying doctrine of some kind of extensive presidential immunity. The Supreme Court in Trump versus United States addressed an extension or new application of this longstanding principle of presidential immunity. The court sets out two categories of potential immunity. The first represents a category that the court describes as involving core executive functions, and arguably this is a relatively modest subset. It involves functions for which a president historically has been understood to have complete discretion, areas that Congress lacks the power even to regulate, so it's very specialized. The courts list several areas: exercises of the pardon power, discretionary aspects of the removal power, and the power to recognize foreign sovereigns. And these categories do not extend nearly as far as some of the prepared testimony today suggests. The court's talking about the core, inner kernel of presidential authority and decision-making for which the president essentially has complete discretionary power. Decisions such as whom to nominate or fire or whom to pardon. Then there's the middle category that the court describes as extending to the outer perimeter of a president's executive functions. And in this area, the court does not definitively determine whether absolute or presumptive immunity applies. At a minimum, though, the prosecution would have to show an actions manifestly or palpably outside of presidential authority before bringing charges based on that action. And the court left many of the remaining details for the lower courts to work out on remand. Finally, one additional point. The institutional integrity and norms within each of the branches of government has faced repeated threats and challenges. Some are very recent, like attempted violence and the New York Times report of yet another breach of confidentiality outside the longstanding norms of legal practice and service within the Supreme Court. Maintenance of longstanding norms of civility, humility in public service, principle, and integrity necessitates a sober approach to the characterization of governmental actions, and it involves taking a careful, studied look at the actions of fellow governmental servants. Thank you so much, and I look forward to the committee's questions.
Thank you, Professor Mascott. Professor McCord?
Distinguished members of the committee, thank you for inviting me to testify about the potential consequences to government functions of the Supreme Court's decision in Trump v. United States. Like my colleague, my organization at Georgetown Law is a regular litigant before the Supreme Court, and I have respect for the institution of the court. In my government career, I served for nearly 20 years as a federal prosecutor under Republican and Democratic administrations. I served for 3 years at Maine Justice, first as Principal Deputy Assistant Attorney General and later Acting Assistant Attorney General for National Security, and I stayed through transition to the Trump administration before leaving in May of 2017. I agree that a president is immune from criminal prosecution for exercises of core constitutional powers. These include the pardon power, the veto power, and other powers committed to the president by the Constitution or recognized throughout our nation's history. For these exercises of powers, the president's authority is conclusive and preclusive, meaning that Congress may not act upon it, nor may courts examine it. My concern is that the majority's opinion in Trump v. United States capaciously defines core constitutional powers to extend far beyond these well-recognized powers. Concluding that the investigation and prosecution of crimes is a quintessentially executive function, the majority holds that the former president is absolutely immune for alleged conduct involving his discussions with Justice Department officials. That conduct includes the indictment's allegations about efforts to leverage the Justice Department to convince certain states to replace their legitimate electors with fraudulent Trump slate of electors. The majority seems to source this in the Take Care Clause, but that clause says that the president shall take care that the laws be faithfully executed, explicitly recognizing Congress's role. Justice Amy Coney Barrett recognized this, writing separately that Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including through criminal statutes. She would not read the Take Care Clause so expansively. Unfortunately, Justice Barrett's well-reasoned concurring opinion did not command the majority. The potential abuses of official power that are made possible by the court's ruling and the neutering of Congress's ability to act are alarming. Consider first the Department of Justice. Is Congress now disabled from tying the appropriation of funds to certain areas of law enforcement, or from enacting legislation that governs department organization and functions, or from oversight requesting records and testimony from department and FBI leadership? What would stop a president from directing the investigation of his political enemies, journalists, or activists, even where there is no basis for doing so? The majority said, after all, and I quote, "The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials." Could that sham investigation include directing the FBI to engage in unlawful surveillance, or bypass seeking a warrant to search a home or workplace, or to target individuals or groups based on race or religion? If the president were to bring a civil suit against the Department of Justice, as the former president has provided notice that he intends to do, could he order the department to settle the case for millions of dollars, even if the suit itself were baseless? Moreover, the rationale of the majority's decision would appear to apply to all departments and agencies. No potential criminal prosecution would prevent the president from directing the IRS to launch baseless criminal investigations. Likewise, no potential criminal prosecution would prevent the president from using the CIA for domestic operations. The reforms enacted by Congress in the wake of past abuses would be impotent in the face of a president unconcerned about adhering to the rule of law. Finally, the decision leaves open whether the president's immunity could be extended to subordinates and whether the defendant's limitation on the admission of official acts evidence, even in a prosecution for purely private acts, might be extended to subordinates. But they might not even need that protection if the president promises pardons. This would not only remove an important deterrent to engaging in unlawful abuse of power at the president's direction, it would effectively negate Congress's criminal contempt authority, ending congressional oversight of the executive branch as we know it. I refer the committee to my full statement on the record and look forward to your questions.
Thank you, Professor McCord. General Mukasey.
Chairman Durbin, Ranking Member Graham, and members of the committee, I'm grateful for this chance to address the Judiciary Committee, which I understand is meeting to consider some of the ramifications of the Supreme Court's decision in Trump versus the United States. Now, I understand that because that's what I was told, although I have to begin by saying that, as Senator Kennedy did, that I believe the title of this hearing, when the president does it, that means it's not illegal, the Supreme Court's unprecedented immunity decision. That title, I don't think, is a reasonable description of what that decision actually said, its effect going forward, or its rather unremarkable and firm basis in precedent. This is the first case in which the court has ever had to consider the extent to which a former president can be prosecuted criminally for acts committed while in office, because this is the first time a former president has faced criminal prosecution. But as Professor Mascott pointed out, the court was not writing on a clean slate. In an earlier case, Nixon against Fitzgerald, decided in 1982, that case had already held that a former president was immune from being sued civilly for acts at what was called the outer perimeter of his official duties that he performed while in office. That opinion, in turn, was based on precedent going back to Justice Robert Jackson's concurring opinion in Youngstown, Cheaton II versus Sawyer, which I think is still considered the authoritative description on the reach of presidential authority, and a discussion of the executive vesting clause in Marbury versus Madison to the effect that a president's official acts are not subject to examination in the courts. I believe the court's ruling here was narrow, consistent with precedent and constitutional principles, and that the three categories of presidential conduct that the court discussed in its immunity analysis are themselves anticipated in Justice Robert Jackson's opinion, beginning with acts at the court of presidents of constitutional power, such as the power to pardon, conduct foreign relations, and other acts, such as speaking in certain settings and circumstances that are presumptively immune, and acts that are clearly private, which are not. The ruling here was also modest in the sense that the court sensibly remanded the case to lower courts for them to consider in the first instance, in the normal course, how to distinguish what might be official acts from those that are not, and to determine whether even some official act can be the subject of criminal prosecution if such a prosecution would not impair the functioning of the executive branch. The policy rationale for the immunity recognized in Nixon against Fitzgerald and the current case is the ability of the presidency to function independently and with vigor. Now, I don't want to simply reiterate the analysis provided by Professor Mascott or the analysis in the majority opinion. Rather, I'd like to focus these, with which I agree. Rather, I'd like to focus these brief remarks on two claims in the dissenting opinions. The first is the effect that the majority opinion would immunize the president from criminal prosecution for directing the military to assassinate a political rival, or from organizing a coup, or from taking a bribe to confer a pardon, or from removing a cabinet official by poisoning him. I believe respectfully that the dissenters attribute a complete lack of common sense to the majority and thus misread the majority's view of official acts. Just to take the first of these horribles, directing the assassination of a political rival, under certain circumstances, the president is empowered to use lethal force, even to kill an American citizen, but based on findings prescribed in a statute. A president, as commander-in-chief, is empowered to authorize the extrajudicial killing of an American abroad, as was done in the case of Anwar al-Awlaki. President Obama should not be, and by any common sense standard is not, subject to criminal prosecution or punishment or civil liability, even based on a claim that some of his findings were not correct or were inadequate. But even though the president as commander-in-chief may direct the military to do acts that are lethal, I don't think there's any sense in which, in order to do something facially unlawful, like assassinating a political rival or organizing a coup, could be considered an official act consistent with the majority opinion. In fact, although in a footnote, the majority makes the obvious specific by saying that the president could be prosecuted for taking a bribe in return for a pardon, so long as the bribe and the public record of the pardon could be proved, without delving into the deliberations underlying it. Now, there were those who claimed that President Clinton should have been prosecuted or could have been prosecuted for giving a pardon to Mark Rich in return for a contribution to his library by Mr. Rich's former wife. That case was never brought, and I think wisely. The second feature of the dissent that I want to touch on is the claim that the immunity suggested by the majority is unnecessary because, as Justice Sotomayor asserted, every sitting president has so far believed himself under the threat of criminal liability during his term in office and nonetheless has boldly fulfilled the duties of that office. Or, as the current Justice Jackson put it, America has traditionally relied on law to keep its presidents in line. Now, I see I'm approaching the end of my time, but I have just a couple of seconds more. I served under only one president, President George W. Bush. That said, I did have occasion to participate in meetings relating to military activity abroad, to the allocation of resources to certain law enforcement activities as opposed to others, and the like, and never saw any indication that what guided those decisions included any consideration of possible criminal prosecution by a subsequent administration for authorizing military action without proper basis or conspiring to obstruct the functioning of any one agency by allocating resources to another. I don't think that President Roosevelt considered or should have considered possible criminal prosecutions by a subsequent administration for what's now considered a shameful commitment of U.S. citizens of Japanese ancestry during World War II, with the active support, by the way, of the then governor of California, or for subjecting the saboteurs to a military trial when the courts were open. I think if one examines the historic record of controversial acts by presidents, it would be dangerous, particularly, although not exclusively, as to acts that impact national security, such as border or drug enforcement, to subject presidents to the constant threat of prosecutions for official acts when they leave office. And even more pointedly, I doubt that many people think that our country would be better off if prior presidents had in fact been subjected to those prosecutions. Now, many criminal statutes are broadly worded and could apply to the official acts of a president. For example, the conspiracy statute has been held to criminalize any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. And as the Supreme Court has noted, virtually every president is criticized for insufficiently enforcing some aspect of federal law and could be hailed into court by an enterprising prosecutor for doing that. Now, we've never required presidents to function under the threat that their official acts might subject them to criminal charges under a subsequent administration. What's allowed our system to function is that even in doubtful cases, we have so far declined to become the kind of country in which incoming administrations take out their grievances against their predecessors by prosecuting them, and I don't think we should become that kind of country. And I thank the committee for its indulgence in letting me go over my time. Thank you.
Thank you very much, General. Dr. Naftali,
Distinguished members of the committee.
would you make sure your microphone's on? Thank you.
Distinguished members of the committee, I am honored to be in the witness chair today. I apologize that my voice is a little rough. I am a professional political historian, not a lawyer. So please indulge me a story. It is a story of what was presented as an official act, but I hope one that we will all agree had illegitimate motives. The President of the United States had launched the investigation of Jewish Americans in a meeting with his chief of staff. The government is full of Jews, he said. Second, most Jews are disloyal. The president then used his constitutional authority over the executive branch to order the White House to, quote, look at any sensitive areas where Jews are involved, adding, in those areas, we have got to get the man in charge who is not Jewish to control the Jewish, and his voice trailed off. In short, he told his chief of staff he wanted the Jews checked. The president, the most powerful individual in the world, was gripped both by anti-Semitism and conspiracy thinking. He told his closest aides that, quote, Jews are born spies. He wanted this investigation to find every Jewish cell, observing to his chief of staff and press secretary that there was, quote, a strange malignancy now that seems to creep among them. These are not my words. These are the words of a modern American president in the nuclear age. And they suggest, I would argue, the corrosive and dangerous capacity of unchecked presidential power. The year was 1971, and the president was Richard Nixon. The infamous Watergate break-in was still a year away. As we assess the effects of the Supreme Court's decision to remove additional guardrails from the presidency, I suggest we consider some events of the year 1971 and a few other well-documented episodes of presidential abuse of power. They are in my prepared statement. They suggest, I would argue, an historical playbook for abusing power by the executive branch under the guise of official acts, and might also suggest ways of anticipating and restraining future abuses in the absence of the deterrent of criminal prosecution. In 1971 alone, the Nixon White House, besides calling for a census of all Jewish Americans in the US government, although one was only done for a part of the Department of Labor, the president wanted to remove every Jewish economist in that part of the Department of Labor, but they were protected by civil service statutes. The same summer, the president ordered a tax list and wanted his political enemies to be audited by the IRS, and the president established an investigative unit within the White House, both to seek and investigate leaks and declassify records that could be used against his political enemies. That group is more famously known as the Plumbers, and that group committed a covert operation in the Los Angeles area, which the president learned about afterwards and was quite happy about. From 2007 until 2011, I served as the first federal director of the Richard Nixon Presidential Library and Museum. In 1974, the Congress had passed the Presidential Recordings and Materials Preservation Act. Among its provisions is a requirement given to the Archivists of the United States that the review and disclosure of presidential materials reflect, quote, the need to provide the public with the full truth at the earliest reasonable date of the abuses of government power properly identified under the generic term Watergate. 4 decades later, with the creation of the Federal Nixon Library by the National Archives and the transfer of Nixon presidential records from College Park, Maryland to Yorba Linda, California, that work continued under my delegated authority. I am here to provide a few brief historical cases that would possibly illustrate future unintended consequences of the Supreme Court's decision. They are a warning that an energetic executive isn't always in the public's interest. Moreover, when the use of presidential power is untethered to the motives for which it is being used, there arises the opportunity for corruption and the appearance, at least, of criminal behavior. If I may have just a few more seconds. My examples come from the period that led your predecessors in the 1970s to create additional guardrails, not so much to rebalance the tripartite equilibrium, but to make it harder for the Article II institution to abuse power. I refer to presidents of both parties, but the greatest detail I'm offering is from the Nixon era. That doesn't reflect a belief that Nixon was unique as an abuser of presidential power, though the intensity of his real and attempted misuses of power arguably put him in a special category. It is that his administration is by far the most thoroughly documented for any president. We know his motives. We don't have the same level of documentation for motives for the Kennedy and Johnson years, for example, despite their presidential taping systems. I submit that the principal takeaway from these cases is that motives do matter in the application of constitutional authority and the determination of whether an act is an official act, and that presidents ought to be held accountable, if appropriate, by the courts as well as the Congress for the motives that animate their decisions. All of these cases illustrate the public interest and arguably congressional interest in determining motive, even if the Supreme Court isn't interested. The improvement of taxpayer compliance is a justifiable presidential motive. Deterring leaks of national security secrets is another. Ensuring security at a political convention. One of my cases is of Lyndon Johnson's misuse of the FBI against black Mississippians who challenged the seating of the regular all-white Mississippi Party at the 1964 convention. So too is the accuracy of government statistics. But when these are veils to permit unethical and potentially illegal acts, then the question arises, who or what protects the public from the president? In this new constitutional environment, the question is only confidentially answered in the negative, not by the courts. The Congress, the Article I Constitution, should be concerned. The president's ability to request investigations, whether of an individual's tax return, of their service jacket, to request a name check against FBI records, to inquire into their religious faith, seems limitless. And history has powerful examples of how that power has been abused. Congress is now the last line of defense against presidential abuse of power, which we would be naive not to assume will happen again.
Thank you, Dr. Naftali. We'll now go to rounds of questioning. We each have 5 minutes to ask questions of the witnesses. I'd like to say at the outset that there have been at least one, maybe two, who've questioned the title of this hearing, which includes the words, "When the president does it, that means it's not illegal," all in quotes. Who were we quoting? Richard Nixon. Who could we have quoted? Perhaps Donald Trump, who said presidents have to be given total immunity. They have to be allowed to do their job. And it turned out that was his defense, which he brought before the court in the Supreme Court decision, which we're questioning. My colleague, Senator Kennedy, made a point that there's still the authority and right of a prosecutor to prosecute criminal activity of a president in certain circumstances under this decision. But as he went on to say, they have to prove beyond a reasonable doubt. I'd like to add that there was also a part of this decision which limited the use of evidence by prosecutors. And that was noted not just by me, but certainly by Amy Coney Barrett, a Trump appointee to the Supreme Court. Here's what she said. Before I quote her, the holding was a bridge was too far for her. She argued that, quote, "The Constitution, of course, does not authorize a president to seek or accept bribes, yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution." Professor McCord, as a former prosecutor, would you walk us through what prosecutors need to establish to successfully secure a conviction, and exactly how this prohibition on evidence in the Trump versus United States case would prevent prosecutors or harm their efforts to do so.
Yes, a prosecutor, of course, to prove any criminal case must prove beyond a reasonable doubt every element of the offense charged. And to do that, they introduce evidence into court that establishes those elements and argue to the jury that the elements have so been proven. By hamstringing a prosecutor, even in a prosecution that the Supreme Court has now told us is possible, a prosecution for unofficial acts, purely personal acts, by barring evidence of official acts in those prosecutions, that severely hamstrings the government, as Justice Barrett pointed out in her dissent to that part of the court's opinion.
Justice Barrett went on to say, allowing into evidence official acts for which the president cannot be prosecuted, the argument that they may prejudice the jury is already addressed by the rules of evidence, which, quote, are equipped to handle the concern on a case-by-case basis. Do you agree with that?
I agree with that, Chair Durbin, and that includes when evidence might be more prejudicial than probative.
Mr. Lacovara, you have noted that it's impossible to find the basis for presidential immunity in the wording of the Constitution. Would you like to address that to those who are originalists?
Yes, this is one of the great ironies of the decision by Chief Justice Roberts. It's not just a question of not being able to find authority in the text of the Constitution for any form of immunity, absolute or even qualified for commission of crimes by a president. The Constitution expressly says the opposite. The president is subject to impeachment. Indeed, Article 2 is quite explicit in saying the president and all other officers in the executive branch are subject to impeachment. And then the impeachment clause, this is in Article 1, Section 3, about the role of the Senate in trying impeachments, says judgment shall not, in an impeachment, shall not extend beyond removal from office, so that unlike in Parliament, where a penalty such as death could be imposed by Parliament, only upon conviction is a official such as the president removed from office. But then the text goes on to say, but the party convicted, that includes the president, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I think it could not be fairer or more obvious that the framers of the Constitution intended that a president, whether or not impeached and removed, is subject to the normal course of law, as the text said, if his conduct, his official conduct, was not only impeachable or possibly impeachable, but also a violation of criminal law.
Thank you. I want to close by referencing a statement made earlier by my friends on the other side of the aisle. Never should anyone interpret these hearings as an invitation to violence against anyone, period. The Supreme Court Justice or any person involved in our nation's affairs and public interest in public policy. Holding a hearing on a Supreme Court decision is almost routine in this committee. The fact that we've done today, I think history will judge, is the right thing to do in light of the gravity of this decision. And secondly, questioning the ethics of the Supreme Court happens to be our responsibility under the Constitution, Article 3. I think we should continue to do that and not be questioned on our motives when we do. Senator Graham.
Thank you, Mr. Chairman. Let's kind of pick up where you left off there. It's okay to criticize the court. We all do it. I mean, they're subject to criticism. You know, were you right, were you wrong? Can we all agree on the following? That Justice Sotomayor and Kagan are honorable people. Does anyone disagree with that? Now's your chance to say so. Do you feel the same about Justice Roberts? Okay, I agree with you. I don't agree with Sotomayor and Kagan's dissenting opinion, but I don't doubt that they're motivated by what they think's best. Let's go back to how all this plays out in the real world. Is this the first case in the history of the country where a former president has been pursued criminally? Is this the first time that's ever happened in the country, the Jack Smith prosecution of former President Trump? We all agree? Okay. Well, this is a case in controversy. It's never happened before. Now, what do you do once it has happened? How do you deal with it? What are the rules, if any? So let's talk about, in the footnote, it says that you could prosecute a president who took a bribe for a pardon. How do you say your last name, sir? Phil?
Lacovara?
Okay, Mr. Lacovara, you agree with that?
Yes, I certainly agree with that.
Okay, so I do too, but it also says you can't go into the motive stuff because I don't know where all that ends. So explicit grant of authority to a president seems to have a standing with the court different than things that are not specifically addressed by the Constitution, which makes sense to me. Now, having said that, let's get back to our own history. You're a historian, and I don't know when it was, I guess probably 1942, whenever it was. President Roosevelt put everybody of Japanese descent in an internment camp. Am I right about that? And his motives were to protect the country from another attack, and thought that maybe Japanese Americans may be more loyal to Japan than America. Is that sort of what he was thinking, you think?
Yes. Oh, yes, yes, sir.
Okay, all right. Do you agree at its core it was inherently racist?
It definitely was racist, yes.
Yeah, okay, so you had a motive to protect the country that's inherently racist.
Mm-hmm.
Should he be prosecuted for that? I think probably not. So it's a hard question. I'm not playing games here. You know, we're living in a real world of where presidents are bad people, good people. Some good people do bad things. What's the role of the law here? So if we don't do what the court did, Professor Mascott, what happens to the presidency over time in your view?
Well, I mean, the presidency could continue to face political attacks after the fact, and presidents who are hamstrung and unable to serve by folks coming after the fact and raising politicized prosecution. So I think the court here is trying to issue a modest opinion.
Is it a road to banana republic if we don't have some rules?
Yes, because what it would do is turn the court system and criminal prosecution into a weapon that replaces the political branches. So one thing that I think was hard to maybe see from some of the...
Just hold that
sure.
thought. Mr. Mukasey, are you concerned about the weaponization of the law against President Trump?
Yes, because it's not simply President Trump, it's any subsequent president who would have to look over his shoulder to assure that his decisions are not subject to possible criminal prosecution. The weaponization of, I mean, the very term weaponization suggests that the criminal law is being invoked for improper reasons. I have no hesitation about the application of the criminal law to either President Trump or any other president or any other public official who violates the law, but that's a very different thing.
Okay. The idea of, say, the president ordering the assassination of his opponent, is that official act?
No.
Okay. Yeah, I don't think so either.
I mean,
That's nose good.
just to use a less dramatic but equally...
Nose good.
Yeah, just to use a less dramatic...
Good, right, okay, good. So, what I want to say is, the hearing, title, whatever you want to call it, is suggesting that the court somehow has unleashed upon the American people an evil force. I don't buy that one bit. I think the court is dealing with a case before it in a rational way. We can all disagree. I think everybody on this panel is honorable. I think everybody on the court is honorable. Thank you.
Senator Whitehouse.
Thanks, Chairman. Professor McCord, the Constitution repeatedly refers to the term treason. How does treason fit into your analysis of the immunity decision? How well is the constitutional concern about treason reflected in the decision?
Thank you, Senator. The decision, of course, does not speak to treason and whether treason would be prosecutable. I think the court's decision would have to be applied based on what the court told us, which is that actions within the president's core constitutional powers, as apparently capaciously defined, would be absolutely immune. Other actions within the outer perimeter of official acts would be presumptively immune. And so I think it would depend on the facts, frankly, that surround the allegations of treason. The Constitution, as you of course know, specifies that members of Congress are not immune from prosecution for treason. And of course, the Constitution provides that impeachment may be based on treason. And the Supreme Court just hasn't really answered the question in its opinion with respect to criminal liability.
It strikes me that if the decision were as modest as some members of the panel suggest that it is, the court could easily have modeled the Constitution itself and said, except treason. Instead, they presumably know the Constitution, they presumably looked at it, they presumably saw the exemption for treason in legislative immunity, the definition of treason in the Constitution, the use of treason as not only a basis for impeachment, but for subsequent criminal prosecution, and then left out treason. Mr. Lacovara, if you take a look at this decision and think back to your days in the Watergate case, how do you think it would have affected the prosecution of President Nixon, the investigation and prosecution of President Nixon?
It certainly would have affected the investigation enormously, Senator. The focal point for the appointment of the special prosecutor was the apparent or alleged role by President Nixon in orchestrating the cover-up of the responsibility for the Watergate break-in by using his official powers, his power indeed over the CIA to urge the CIA to interfere with the FBI investigation. So there was no doubt that the president was viewed as potentially having abused his official authority over executive branch agencies. And as I emphasized in my opening remarks and in my prepared statement, everyone understood at the time, and I believe this is true from my having argued the Nixon tapes case in the court, all of the justices on the Supreme Court up through that time from the beginning of history assumed that a president may in fact be held criminally liable for criminally misusing his powers. And the only issue was whether the president, in that case President Nixon, who was charged by the grand jury as an unindicted co-conspirator, thus having borne criminal culpability, whether the president, while still in office, could be indicted, or whether indictment and prosecution of President Nixon had to wait until after he left office. That's what gave rise to the controversy that led President Ford to avoid what he called the national nightmare by issuing a pardon in order to prevent what was expected to be the indictment of President Nixon for having committed those offenses.
And is it not true that the acceptance of a pardon constitutes an admission of criminal guilt?
As a matter of law, the acceptance of a pardon is an acknowledgement of criminal guilt.
No mention of that in this decision either. Professor Naftali, how did the founders, in terms of the dangers that they foresaw for the republic they were creating, how did they rank the danger of an unchecked president?
Well, my specialty is not the history, the early history of our country, but as a professional American historian, I know something about it. I think it's interesting that the court, and I'm not offering constitutional interpretation, but that the court quoted Federalist 70 in support of an energetic executive. One of the fun things when I'm teaching the history of the presidency is I have the students look at what various framers said at various times, and they in fact debated the nature of our presidency. But you don't have to look at a different framer, you just have to look at Hamilton, because when Hamilton was trying to sell the idea of a unitary presidency as opposed to the collective presidency, there were a whole bunch of models that were discussed at the convention. He made the argument in Federalist 69, and the following argument is, and I'll quote it, because I think it's rather, it gets to right to your point, Senator.
Good, because
The President of the United
cut you off
States.
after the quote,
Yeah,
'cause
I'm
my
sure.
time is up, so
The
finish
President of the
your
United
quotation.
States would be liable to be impeached, tried, and upon conviction of treason, bribery, other high crimes of misdemeanors, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law. The person of the King of Great Britain is sacred and inviolable. He was making the difference between our president and the King of England. They could be tried in a court.
Thanks,
American
Professor.
president.
Thank you, Chairman.
Thank you.
Senator Lee.
Thank you, Mr. Chairman. Thanks to each of you for being here. Chief Justice John Roberts, in his majority opinion in the case that we're discussing today, noted that, quote, "This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency." Look, we wouldn't be here today if the progressive left, after trying not once but twice to impeach President Trump, brought the first criminal prosecution of a former president in our nation's history based on acts undertaken during his presidency. And they all celebrated the politicization of federal and, in many cases, state prosecutors when all this happened. Now, look, my colleagues on the other side of the aisle, some of them at least who we've heard from, one could argue that they made up their mind about this case long before reading the briefs, much less the opinion or even the cert petition, just based on one name, on the name Donald Trump. The fact that the petitioner in that case was named Donald J. Trump meant that they were going to be against whatever it is that he argued and any court ruling that maybe came down on his side. But look, all of this is part of a pattern and practice of lawfare, a mechanism by which a number of prosecutors, including many elected prosecutors who ran specifically on the platform of criminally prosecuting Donald J. Trump and have prosecuted on going after other people whose political views that they don't like. And so in this respect, it reminds me a little bit of what our colleague, Senator Chuck Schumer, did to threaten two members of the Supreme Court, Justices Kavanaugh and Gorsuch, when he went to the steps of the Supreme Court back in 2020, and he delivered this choice soundbite. Quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions." So look, the left knew their preferred outcome in this case based on the criminal defendant, on the petitioner before the Supreme Court, before the first arguments were made at the earliest stages. This is something that we need to look to. Now, some of my colleagues have commented today about the legitimacy of the opinion, including suggesting that it was borne out neither by a textualist nor an originalist analysis of the constitutional text in question. Professor Mascott, I'd like to start with you. Tell me what you think of that assessment that this is somehow counter-textualist or counter-originalist for the court to have reached this conclusion regarding presidential immunity.
Thanks, Senator Lee. Well, as the opinion notes, it's based on longstanding structural understandings of the constitutional system. For example, we have a concept of sovereign immunity. The government itself has a little bit has a well of immunity, and the president and the vesting of the executive power in the vesting clause has inherent immunity. And this is the doctrine that was recognized decades and decades ago, repeatedly by the Supreme Court, albeit in the civil context, and even during the Clinton administration and before. And it's essential to the president to be able to do his job. Not that every action he's going to take is always going to be deemed legal. There are plenty of ways to challenge actions in court, to enjoin actions, to go against the action itself, to defund actions, to impeach and convict a president, but not to subject him to criminal prosecution for doing his job.
So in other words, they're not making this up. It is rooted in text. It is rooted in the structure. But there are centuries-old precedents that we rely on, some of which predate the founding of our republic. Is that right?
That's correct, and in the concept of executive power itself, properly historically understood.
And the President of the United States is himself the living embodiment of the executive branch.
That's correct.
the
He's the only individual who sits at the top alone of a branch of government.
Right. And so these things were born of necessity many centuries ago, in many cases before the founding of our republic, but were understood at the time the Constitution was written. General Mukasey, when you look at what would happen if we didn't have this doctrine, even if we just didn't have this ruling, let's say if the outer perimeter category identified by the Supreme Court, that seems to be attracting a lot of the scrutiny today, if that did not exist, how would that impact the American people through the route of presidential actions? In other words, if a president, let's say, for example, President Clinton, when deciding to order a military strike that happened to arise at the same time certain scandals were erupting surrounding Monica Lewinsky, if that could subject him to some type of criminal prosecution, or a grant of a pardon at the same time somebody else had an interest, as you mentioned in the case of Mark Rich. What kind of impact would that have on the American people through their president if presidents had to look over their shoulder constantly in evaluating their own personal future stake in this and what could subject them to criminal prosecution?
Well, in the case of the attack that President Clinton authorized, which was decried by some people as a diversion, obviously the security of the people would be compromised because there would be hesitation over the order to direct that attack, notwithstanding that it was designed to protect the people of the United States from foreign hostile actors. As far as the pardon, that if that was a legitimate exercise of presidential authority, the ability to grant pardons and would itself be compromised.
In other words, we would be opening up a hornet's nest. This would be a Pandora's box, to put it mildly, that we would be opening if we didn't have this.
Presidency would be whittled away by repeated considerations of possible future consequences.
Thank you.
Senator Rono.
Thank you, Mr. Chairman. I thank all of the witnesses. We have a Supreme Court majority busy overturning decades-long precedent, and so let me cite some of the better-known decisions. And I do this as illustrative of the Supreme Court's willingness to overturn precedent as well as create new precedents. For example, in Citizens United, we learn that corporations are people and opening the floodgates, basically, to the dark money that is flooding our elections. In Shelby County, we see the Supreme Court eviscerating a major part of the Voting Rights Act. And in Janus, the Supreme Court overturns decades-long precedent that enabled public sector unions to collect fees even from non-members who they had to represent. Excuse me. I heard mentioning of Korematsu. The thing is that when the Supreme Court makes a decision, even if it's wrong, it can stand, and the Korematsu decision stood until 2018. So when the Supreme Court makes a decision, it has ramifications of longstanding. Then we have Brnovich, which, again, it further limited the protections of the Voting Rights Act. And by the way, did I mention Shelby County, where suddenly the majority decided that to eviscerate, as I said, the Voting Rights Act, and soon thereafter, 13 states passed all kinds of voter suppression laws, and under Brnovich, they went even further. In a more recent case, Bruin, the Supreme Court, again, decided that to sustain gun safety laws, they should look to precedents going back to 1791. And of course, we have the Dobbs decision, which overturned almost a 50-year, what women in this country thought was a constitutional right that the Supreme Court should be protecting. More recently, in 2023, we have the Harvard affirmative action case, which the Supreme Court tossed out, meaning that Harvard's ability to refer to race as a way to have a more diverse student body, that was tossed out. And then, because of the outcome of the Bruin decision and all of the aftermath of that, There was another case where they had to kind of walk back their Bruin decision. And then we have the more recent 2024 decision where the Supreme Court overturns a Chevron decision, and that's going to create all kinds of problems. And now we have the Supreme Court creating new precedent in terms of presidential immunity, and this is going to have far-reaching consequences. And of course, you know, it's already having impact, totally foreseeable impact on the Trump cases. In the DC case, the parties are briefing issues raised by the Trump decision, and Judge Chutkan is going to have to make certain fundamental decisions on that. There's no question that this immunity decision helps Trump. In the Florida case, it was totally dismissed by Judge Cannon based on, of all things, Justice Thomas's, it wasn't even part of the majority decision. So there, it's like, wow, that just raises so many questions that she would toss out the case based on Justice Thomas's concurrence. And then we have the New York case where Trump is wanting to set aside all 34 convictions. So we have a Supreme Court that is making these kinds of far-reaching decisions, and in this case, I don't see how anybody can say that it doesn't help Trump. So I have a question for Ms. McCord. You know, I think you went into this a little bit with the questioning from our chair, but if you can't bring in the motivations, regardless of whether the motives may have been based on his responsibilities as the president, how can you prove that the president was doing things that should hold him criminally liable?
Well, certainly mens rea that includes specific intent to commit a crime, and that is an element of every one of the crimes that's charged against Mr. Trump in the January 6th prosecution. That's required at trial. The Supreme Court has actually said, though, that you can't even look to motive when determining whether the allegations involve official acts or purely private acts. And again, I think that hamstrings the judge in even making those determinations, because if you can't look at the intent, it makes it very difficult to determine in some cases what might be on which side of the line.
So if we look at the pragmatic and practical impact of this immunity decision, I don't see how a prosecutor can overcome the immunity of the president if you can't bring in motives. So as far as I'm concerned, this is a decision that should not be allowed to stand. What do you think about a constitutional amendment that would make it very clear that no one is above the law, including the President of the United States? I ask that of Ms. McCord.
Yes, I'm familiar with your and your colleagues' proposed constitutional amendment, and I think that that is something, you know, that legal scholars can study, but it seems like it is a response that to this opinion. I would note potentially the need to carve out actual core constitutional powers, but I don't think the amendment was necessarily intended to override those.
Thank you, Mr. Chairman.
Senator Grassley.
I'm leading up to a question for Professor Mascott, repeating a little bit what Senator Lee just said. For the last several years, the other side has ratcheted up the political rhetoric against conservatives and other countries in our country's democratic institutions. More recently, they've directed their focus and ire on the U.S. Supreme Court. They've dubbed the Supreme Court as a MAGA court. They've referred to the current member makeup as somehow radical. The Senate Democratic leader threatened to release a whirlwind, as you know all about that statement. Unfortunately, this has all come as a tremendous cost. Justices and their families have endured ongoing picketing outside of their homes, scenes of public intimidation, harassment, and now death threats. Needless to say, this is all totally unacceptable. So to you, Professor, does America have a MAGA Supreme Court, and how would you describe this characterization?
Well, I mean, we have a Supreme Court, and I agree with a lot of what the senators have said and Chairman Graham, where I believe every justice on the Supreme Court's trying to carry out what they believe their constitutional duty is. It's coming under unprecedented attack, which we have not seen, in many years, with breaches of confidentiality across the branches, people facing attacks and threats. And I think it's our, duty here testifying today and setting these actions to do what we can to make sure that they're portrayed in an accurate light and be careful and studied with what they talk about. With respect to this current decision, as you know, the Supreme Court doesn't reach out to take cases. It takes the cases that come to it. And what prompted this was really the unprecedented nature of the criminal prosecution in this case of the current administration prosecuting a current political rival.
Okay. Judge Mukasey, could you briefly describe how the recent Supreme Court presidential immunity case builds upon previous legal precedent and doesn't give the president the authority to have political enemies terminated?
Well, as I pointed out, there is Nixon against Fitzgerald established the principle that there are immunity principles that apply to the presidency. This is a logical extension or plausible extension of that decision. Marbury versus Madison pointed out that the decisions of the president are not subject to examination by the courts. The notion that somehow the president is immune from prosecution for imagined acts, I think is way beyond what the majority said. Just to offer a less dramatic, but nonetheless equally far-fetched example, if the president, as commander-in-chief, ordered the military to shoplift a tie that he wanted to wear to deliver the State of the Union address, that would not be something that is for which there is immunity. Yes, he's commander-in-chief of the armed forces, but shoplifting is not among the prerogatives that he has to order.
Judge Mukasey, can you briefly explain some other attempts to exert political pressure on the judiciary and what was the results of those?
Well, there have been, as was pointed out, there have been threats to limit the budget of the judiciary. There have been threats to strip the judiciary of its jurisdiction, and I think those are very dangerous, and ultimately will wind up damaging the liberties of all Americans.
Professor Mascott, broadly speaking, can a federal statute overturn a constitutional interpretation by the Supreme Court, or would a constitutional amendment likely be required?
Well, in our system, we treat the interpretations by the Supreme Court as a final judgment. So a federal statute, no, would not overturn it. You would need a constitutional amendment, and that's intentional because of the high bar that it takes with the support of 3/4 of the states to be able to get a constitutional amendment, to be able to override previous understandings of the Constitution.
I yield back.
Senator Welch.
Thank you very much, Mr. President, Mr. Chairman. At the heart of this seems to be a core dispute about whether presidential power needs immunity in order to be effective, powerful, and unconstrained, or whether presidential power within the Constitution, adhering to the doctrine of separation of powers, adhering to the doctrine that no person is above the law, needs constraints. The majority in the court made several comments that suggested, actually explicitly stated, that they wanted no constraints so that they could have, as they put it, a vigorous presidency. Justice Roberts disregarded what or diminished the importance of the facts. He said in a memo, in a case like this one, focusing on transient results may have profound consequences for the separation of powers for the future of the republic. our perspective must be more farsighted. Justice Kavanaugh said, I'm very concerned about the future. Justice Gorsuch said, we're writing for a rule for the ages. And General Mukasey, you said you expressed a concern about the powers of the presidency being whittled away. My concern is that the rule of law is being whittled away. My concern is that constitutional freedoms are in the process of being whittled away. What's been whittled away are the checks and balances that are the core of our constitutional system. And Mr. Chairman, what's being whittled away is the Article 1 responsibility of Congress to enforce the rule of law. General Mukasey, I want to ask you to just comment on some of the hypotheticals. I mean, with all due respect to you, and I have enormous amount of respect for your service, talking about ordering the military to steal a tie that you want to wear at the inauguration, I think really diminishes the importance of this. What about a president ordering that political opponents have the IRS pursue them? Is that acceptable or not?
It is not.
So should the president have immunity for that?
The president is, first of all, politically answerable for that kind of behavior.
We're not talking about that.
I know that.
Well, then don't say it.
Okay. I withdraw the comment.
Thank you.
The ordering the IRS without basis to focus its activities on political opponents.
Well, why in the world would the President of the United States, who's got a lot of things to deal with, decide that person A or person B should have the IRS go after them? How in the world, in what world would that be legitimate?
It is not legitimate, as I said.
So should he or she get immunity for that?
No.
All right, what about the professor's recitation of Nixon's focus on going after Jews in government?
Again, no.
So no immunity for that.
Correct.
But under this decision, Professor?
No.
All right,
I gather that question's not directed at me.
No,
Because the answer to that is no as well.
I did direct it to you, but I want to ask Professor McCord.
Senator, I think this is what's left open by the decision. Because the Supreme Court capaciously defined these core constitutional powers as absolutely immune, it opens the door to the very types of activities that my colleague, Judge Mukasey, agrees should not have immunity. Now, there could be other readings, but the Supreme Court doesn't tell us those, and we're left wondering exactly how far this opinion goes.
Well, thank you. You know, Mr. Chairman, this is not about the court. This is about us. It's about how much confidence we have in our capacity as a democracy to govern ourselves, as opposed to transfer that responsibility without limitation to a person in an office who has not traditionally been above the law but subject to the law, and whose responsibility is to serve us and not use authority to abuse us. I yield back.
Thank you, Senator. Senator Kennedy.
Thank you, Mr. Chairman. Thank you for being here. Professor Mascott, this case that we're talking about, Trump v. United States, it was before the United States Supreme Court because the Biden administration decided to criminally prosecute former President Trump. Is that correct?
Yes, Senator.
And in fact, President Biden's lawyer actually asked for expedited review and an expedited decision by the Supreme Court. Is that correct?
Yes, the prosecution would have found expedited review helpful.
When the court handed down its opinion, well, strike that. The title of our hearing is, quote, "When the president does it, that means it's not illegal." And Chairman Durbin explained what he meant by that, but I just want the record to be clear. Did the Supreme Court, in its opinion, ever say, quote, "When the president does it, that means it's not illegal"?
No, that doesn't
Okay.
appear in the opinion.
All right. At the oral argument of this case, President Biden's lawyer actually conceded, did he not, that core functions of a president should have absolute immunity?
Yeah, I do think there's agreement that core functions should have immunity.
In fact, President Biden's lawyer said, quote, "Core functions can't be regulated at all."
That's correct.
Close quote.
Yes.
Okay. What is forum shopping?
Forum shopping is the act of trying to find a court that you think is going to rule favorably to you.
Does it go on in the United States?
Many folks think that it does.
Yeah, it does. It's hard to stop. Let's just stipulate for a moment that America's withdrawal from Afghanistan was not a model of efficiency. People died, including Americans. Can you imagine a scenario with respect to President Biden, now former President Biden? Can you imagine a scenario in which a district attorney in a jurisdiction that repeatedly voted overwhelmingly against President Biden and whose voters did not like President Biden? Can you imagine a scenario in which an ambitious district attorney, after President Biden is out of office, could bring a charge against former President Biden for criminal negligence in the death of Americans? Can you imagine that?
Well, Senator, that would be very troubling, and so that's one of the things.
But can you imagine it happening?
I could imagine district or attorneys wanting to bring such an action, sure.
I mean, now that we've decided that former presidents can be prosecuted, this current case before us is the first instance, but I fear it's not going to be the last. Now, let's suppose this ambitious district attorney in an anti-Biden jurisdiction or venue decided to prosecute former President Biden, which I think would be a mistake. But he meaning former President Biden, would have to defend himself, wouldn't he?
Yes,
And suppose he won, he'd still have to pay his lawyer, wouldn't he?
that's true. And
Are lawyers cheap?
only those of us who teach
No,
law.
strike that. I know they're cheap. Are they inexpensive?
No, they're not.
So President Biden could spend millions of dollars,
That's true.
even if he won.
Yes, sir.
Now, let's suppose after that trial was finished, another ambitious district attorney in another venue or another jurisdiction decided to do the same thing. And then another, and then another. Can you understand what the court was talking about when it said, we can't allow the court system to have a chilling effect on a president, any president, in making these decisions? Can you understand that?
Absolutely. The risk of facing that would certainly significantly impact how a president would make decisions in office, and that's the last thing we want.
Can I have 30 more seconds, Mr. Chairman? Mr., I don't want to mispronounce your name, sir. Don't count my fumbling around against me. Mr. Lacovara?
Never have.
You were vociferous in your criticism of this opinion that the words presidential immunity don't appear in the Constitution. Is that right?
That's part of it, yes, sir.
Do the words separation of powers appear in the Constitution?
No, I acknowledge that there is a structure called the separation of powers.
Is there any doubt in your mind that we have separation of powers in the United States Constitution?
No, and I think it's important to understand what the separation of powers does and does not imply. And
Right.
what it does not imply, in my judgment, is the kind of immunity that the Supreme Court established here.
Okay. Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you, and thank you to our witnesses. Thank you, Chair Durbin, for holding this important hearing on the American constitutional tradition that John Adams stood up for many centuries ago, and that is that a government of laws and not men. Simple concept. You don't even have to go to law school to know it. But I guess I'll start with you, Mr. Lacovara, who did go to law school. You served as Deputy Solicitor General and argued U.S. v. Nixon, along with Leon Jaworski. In your brief in that case, you wrote, "Under our Constitution, the people are sovereign, and the President, though Chief Executive and Chief of State, remain subject to the law." You emphasized the President, like all executive officials, as well as the humblest private citizens, is subject to the rule of law. 25 years after U.S. v. Nixon, commenting on your experience in the Minnesota Law Review, that was a good choice on your part.
Thank you for noting that,
Yes,
Senator.
you emphasized the President, like all executive officials as well, or you emphasized that your goal during Watergate was to enforce the obligation of every citizen, including one who just happened to be president, to comply with the law. Why do you believe the principle that no one person is above the law is a necessary cornerstone of our constitutional system of government?
Senator, I think it's implicit in the very separation of powers that Senator Kennedy was talking about. We separate powers, and the purpose for that, as the framers explained, was to ensure that government is limited. Senator Welch was talking about this as well. They chose liberty over efficiency, and I agree that it certainly would be more efficient, if that were the only goal, to allow the president to do whatever he wants to. But that isn't the system that the framers chose to embody in the Constitution, and I think they made it clear textually what they meant, and as Professor Naftali mentioned, the framers, in their explanation for the Constitution, said the president would be subject to various constraints, including the possibility of criminal prosecution.
Thank you. Very good. Professor McCord, independence from political interference is vital to the legitimacy and success of the Department of Justice. And I thought it would be interesting to ask you some questions about. That's why attorney generals of both parties have established clear policies to ensure that the White House does not tamper with criminal investigations and prosecutions, as Mr. Mukasey knows, or use the Department of Justice for illegal and untoward purposes. I've got concerns that the majority opinion in Trump v. U.S. jeopardizes the independence of the Justice Department. The court emphasized that, and this is the quote, "deciding which crimes to investigate and prosecute is within the president's," I'm paraphrasing that part, "conclusive and preclusive," those are their words, "constitutional authority, an area," this is their quote, "Congress cannot act on and courts cannot examine." You testified that by this logic, there is nothing stopping a president from directing the investigation of his political enemies, journalists, or activists, even when there's no basis for doing so. Can you elaborate on that?
Yes, and thank you, Senator Klobuchar. You're right that, I served in the Department of Justice for well over 20 years, and under every Attorney General, as well as every President and White House counsel, these no-context policies were enforced. They're not constitutionally required. It's not said in the Constitution, but it's something that respect for rule of law and has always dictated that both the White House and the Department of Justice sought to ensure that there was independence. I think that this opinion makes clear that there is nothing stopping an executive from directing his own executive branch, in particular here, the Department of Justice. It's the very directions and conversations with Jeffrey Clark and others at the Department of Justice that the majority holds is absolutely immune. I do think that is dangerous going forward.
Could the court's decision mean that Congress and the courts are powerless to insulate any Justice Department official, from line attorneys to the Inspector General, from the direct partisan control of the White House?
I mean, this is the problem with conclusive and preclusive, and I would note that the case that comes from the Youngstown Steel case, Justice Robert Jackson made clear that when we are talking about a presidential claim to a power at once so conclusive and preclusive, it must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. And the majority opinion, which is of course the governing opinion, well more expansive than Justice Amy Coney Barrett's concurring opinion, which I think is much more well-reasoned and practically applicable, it raises these very issues that you have just posited.
Thank you very much. Thank you, Mr. Chair.
Senator Cruz?
Thank you, Mr. Chairman. The nub of the Democrats' argument today is that the concept of presidential immunity is somehow unprecedented, is somehow remarkable. That claim is utterly ahistorical and disconnected from the entire constitutional history of the Republic. General Mukasey, before 2023, how many times has the President of the United States been indicted?
None.
Before 2023, how many times has a former President of the United States been indicted?
None.
In the last 2 years, how many times has President Donald J. Trump been indicted?
4 times, I believe.
Now, many presidents of both parties have engaged in controversial actions, and yet none of them have been indicted. Let me ask you, General Mukasey, if a private citizen were to erect an internment camp and to forcibly kidnap American citizens, to single them out because of race, and to imprison them based on their race, would that private citizen be subject to criminal prosecution?
Would.
When President Franklin Delano Roosevelt did the exact same thing and erected Japanese internment camps, was FDR prosecuted?
He was not.
Let me ask you, similarly, if a private citizen were, say, to detonate a nuclear weapon over a city and kill over 140,000 people, and then if that private citizen a few days later detonated another nuclear bomb over another city and killed 75,000 people, could that private citizen be criminally prosecuted?
He would.
Was President Harry Truman prosecuted for detonating nuclear weapons over Hiroshima and Nagasaki?
He was not.
All right, how about this? If a private citizen launched a weaponized drone and killed a United States citizen, could that private citizen be criminally prosecuted?
He would.
Was President Barack Obama criminally prosecuted when he killed United States citizens using drones without notice and without due process?
He was not. Although, as far as due process is concerned, I believe the comment of my successor to that question was that Anwar al-Awlaki got, quote, all the process that was necessary.
Well, although I suspect he might disagree with that assessment, were he able to present his case.
Right.
All right. Let's contrast that with the rules that govern other federal officials. You were a judge for 19 years. As a federal judge, did you have immunity from your official acts?
For my official act, yes.
Do federal prosecutors have immunity from their official acts?
They do.
Now, the distinction between official acts and personal acts is not a terribly shocking distinction. Under the decision of Trump versus United States, if any president walks onto the sidewalk and just shoots a citizen, is that president liable to be prosecuted?
He is.
How about this? If a president steals funds from his campaign, does that president face criminal liability?
He does.
How about this? If a president sexually assaults, let's say, an intern in the Oval Office, is the president subject to criminal prosecution for that?
He could be.
So that distinction again, is not a shocking distinction. The Founding Fathers vested the executive power in a single President of the United States. What we have seen in the last 2 years is we have seen Democrats deliberately weaponizing the Department of Justice and our legal system to target their political opposition. It is not an accident that every indictment against President Trump was brought by a Democrat and was brought after he announced his campaign for President of the United States. Understand, the target of those indictments was not ultimately President Trump, it was the voters. It was prosecutors who were terrified that the voters would choose to re-elect President Trump. One of the great things about the United States is we're not a banana republic. Since 2000, the nation of Pakistan has had 6 former prime ministers prosecuted and convicted. Brazil has had 3 former presidents arrested and imprisoned. Last year, Nicaraguan President Daniel Ortega arrested, charged, and imprisoned 40 political opponents. General Mukasey, you are Attorney General of the United States. Is it the proper role of the Department of Justice to prosecute and target the political opponents of whoever happens to be President of the United States?
It is most assuredly not.
Thank you.
Senator Blumenthal.
Thank you, Mr. Chairman. Thank you to this very distinguished panel for being here today. You know, I think this case is wrong. I think the conclusion is wrong by the Supreme Court. I think that its reasoning here is so deeply and desperately flawed. But most important, I think the opinion is completely unpersuasive to the American people. The idea that there is this conclusive and preclusive constitutional authority will have no meaning to the American people, even if it has some meaning to other courts, which I doubt. The court cited almost no authority for its core conclusions here. The longstanding Supreme Court precedent requires it to balance branches' competing interests when there are separation of powers questions. It never engaged in that kind of balancing or cited precedent. It pointed to language from Youngstown Sheet and Tube versus Sawyer, recognizing, quote, the president's authority to act necessarily stems either from an act of Congress or from the Constitution itself. And then it went on with reasoning that is almost impossible to follow. And the opinion was by the Chief Justice of the United States. I think the court really committed a self-inflicted wound here at a time when its credibility is already plummeting. For the Chief Justice of the United States to engage in this kind of substandard opinion, I think is a tragedy. Even if you agree with the result, even if you think there should be some degree of immunity, the quality of this opinion, I think, is so deeply unpersuasive and will be so to the American people that I think it will be a lasting stain on the court. So I want to ask about that wound that the court has inflicted in this opinion, self-inflicted wound that is among others that it has imposed on itself. Mr. Lacovara, maybe you can talk about how the court's credibility is essential to its exercise of power and how destroying that credibility, and I think this partisan divide on this committee reflects what the American people are thinking, which is justices are just politicians in robes. and they've been cited for conflicts of interest. They take cruises on people's boats. They fly on other people's planes, and they're engaged in this political exercise and then put out opinions that seem to have no real persuasive power. What does that do to the court?
Senator, I think that's the perhaps the most upsetting part to me of this decision, that it reinforces what is a growing lack of confidence in the court. And for me and for many others who have spent their lives venerating the Supreme Court and trying to promote the importance of the rule of law as exemplified by the rules laid down by the Supreme Court, it's particularly destructive for the court, and I think you've aptly termed it, to impose upon itself a self-inflicted wound. There was a famous article called the Least Dangerous Branch, which was written back, I think, in the 1950s, and it was in the context of both the court's role in trying to disestablish segregation and push forward civil liberties of various kinds. And the point of the article was the court depends for the effectiveness of its rulings on public acceptance. At the last analysis, it's the effect of the court depends on the public's belief that the decisions are honest, honorable, well justified, and persuasively explained. And I think this decision fails those tests, and that is, in my view, the most troublesome aspect of it.
The court has no armies, it has no police force. It depends on public acceptance and its own credibility for enforcement and obeyance. And, you know, I was a law clerk, like a couple of the members of this panel, for a Supreme Court justice. I've argued 4 cases in the United States Supreme Court. I have the utmost respect, in fact, reverence for the Supreme Court as an institution. And I am so deeply saddened by where this opinion and others and some of the violations of decent ethics standards are taking the court these days. My time has expired. Again, my thanks to all of you for being here. Thanks, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman, and to each of you, thank you for being here today. And I know others have talked about what this hearing really appears to be about today, and I think that the reason is pretty simple, and it is that we have some who disagree with the court's recent decisions. That's why we've had all this talk about reforming the court and packing the court, and it is because we have some that do not like those decisions. And, you know, Mr. Chairman, there's a witness on this panel today who said that the court's legitimacy depended on how the justices ruled in the presidential immunity case. So we get it. We know what's going on here. And we also know that it is imperative that the court be recognized and supported as an independent and co-equal branch of our government. And hearings like this are just more of an attempt to delegitimize the court and the work of the court. And despite some of my colleagues' scare tactics, those of us on this side of the aisle will continue to protect the court's independence. Ms. Mascott, I want to come to you, if I may. Let's talk about what is going on in the court right now. There was the leak of the Dobbs draft opinion, and of course we know that led to near constant protest outside of the Supreme Court justices' homes, death threats, even an assassination attempt. And last week there was a memo from Chief Justice Roberts that was leaked to the public, and then there was an account of the justice's private conversation after an oral argument that was made public, as well as other internal deliberations. This is frightening to a lot of people. And I know that you clerked for Justice Thomas, so talk a moment about the impact that these leaks have on the public trust of the court and on the institution as a whole.
Yes, Senator Blackburn. Well, first of all, these leaks are just deeply unusual and outside of any long understood norm of civility. And as you point out, it seems like at times they're motivated to be able to potentially lead to mistrust in the branch, attacks on what the branch is doing, but also the person who's doing the leak being able to frame the story, as potentially in the case with the New York Times getting presumably selected documents handed to it. And they also violate deep-seated norms of confidentiality, not just within the judiciary itself and the justice and the clerk relationship, but just in general, the legal responsibility to have confidentiality with clients for deliberative decision-making. And it's just a well-understood duty that we have. And so it's very troubling, as you point out.
Let me ask you this. Do you think these are deliberate attempts to persuade justices or influence their decision-making process?
It's certainly hard to know the motivation of the leakers. As you point out, what it led to, particularly in the leak of the Dobbs opinion, was something even far more serious, which is threats on the life of the justices. Thankfully, though, it seems as though any attempt to influence the justices was turned away because the final opinion in Dobbs was strikingly similar, I think, word for word to the leaked opinion.
Let me ask you about that. I found it so interesting. Section 1507 of Title 18 makes it illegal to protest outside of a judge's residence with the intent of influencing that judge's decision. And after the Dobbs leak, and when the justices were facing this intimidation, despite that, the DOJ has refused to enforce Section 1507. And I have introduced the Protecting Our Supreme Court Justices Act, which increases the jail time for anyone who tries to influence a judge's decision. So what more can we be doing to allow Supreme Court justices to do their jobs without fear of safety for themselves and their family?
Well, I think protecting confidentiality, I think trying to accurately characterize what the justices are doing, having respect for a co-equal branch. But then also, I think the court's decisions in recent years and just being cognizant of trying to make sure it's carrying out its proper role within our system has helped as well, because there needs to be less pressure put on the court as the answer for all changes in society, which, if I can just make one final point, I think is one reason why this idea of criminally prosecuting a president is so far outside the norm of the entire constitutional structure, because it's again turning to the courts and the judicial system to try to effectuate change and threaten and attack, what's really supposed to be left in many cases to the political process.
Okay, thank you. Thank you, Mr. Chairman.
Professor Mascott, was there an investigation of that leak of the Dobbs decision?
I believe the court conducted a leak, or an investigation, yes, sir.
I think you're right. It wasn't a congressional investigation.
I don't think no, Congress didn't take action, that's true.
And it's my understanding they reached no conclusion as to who might have done it. Is that correct?
That's my understanding as well, yes.
There was a presumption in the questioning earlier that they decided it was a certain party or a certain judge.
Oh, I didn't mean to imply that, no. I don't think we know who it was.
I just wanted to clarify that. Thank you very much. Senator Padilla wanted to return and ask you, but I'm going to wait a minute or so to give him that chance, and then I'm going to adjourn the meeting. I'll make my closing statement now before he returns. Thanks to all the witnesses. I think this was an important, maybe even historic hearing. I'd like to close with the conclusion of Justice Sotomayor in her dissent in this case. She wrote, "Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law and the rest of us must abide. We will not provide a backstop. With fear for our democracy, I dissent." Our next president will take the oath of office in under 4 months. I hope when that occurs, that individual chooses to respect the rule of law despite this cloak of immunity. Because, as Justice Sotomayor noted, the future of our democracy is at stake. What? A minute or two, relax. Senator Padilla.
Thank you, Mr. Chair. Appreciate the patience and the accommodation. Hello to the witnesses. Apologize for the delay. I was presiding in the Senate. A vote just opened, but I'm back here now as a proud member of this committee for this timely and important hearing. Now, there is one point in which the majority in Trump v. United States and I fully agree, Mr. Chair. The criminal trial of a former president for attempting to disrupt the peaceful transition of power is a matter of, quote, lasting significance. That was in the ruling. Couldn't agree more. I also agreed with the Chief Justice that the court's focus in deciding the case ought to have been, quote, the enduring consequences upon the balanced power structure of our republic. Unfortunately, for our democracy, it was not. Instead, the court's majority was satisfied with inventing a new form of presidential criminal immunity so sweeping that the court declined to designate a single action that Donald Trump took in the lead up to the January 6th riot at the Capitol as, quote, unofficial. And in doing so, the court undermined a core principle of our government, that the president, as Alexander Hamilton put it, is, quote, amenable to personal punishment, and not a king who is, quote, sacred and inviolable. Where the majority fears that the dissenting justices were, quote, content to leave the preservation of our system of separated powers up to the good faith of prosecutors, end quote, I am far more troubled that the court's right-wing majority that now left that task to the good faith of convicted criminals like Donald Trump. Let's be clear. The court's decision to effectively let Trump off the hook has already caused devastating harm for our country, especially to voters and election workers. Trump has essentially been given a pass for weaponizing the Department of Justice to bully states into drumming up false election fraud charges, for his attempts to pressure Vice President Pence into helping him steal the election, and for inciting a violent mob to storm the Capitol on January 6th. And we're continuing to see the fallout. Texas law enforcement, fueled by Trump's false election fraud claims, has harassed Latino voting rights activists, candidates, and even sitting elected officials. In the state of Florida, law enforcement has targeted individuals who signed a petition for a constitutional amendment to protect reproductive rights. And across the country, there has been a surge in abusive public records requests aimed at election offices. We're even seeing naturalized United States citizens who are eligible voters being stripped from voter rolls without due process. The actors behind these examples clearly feel untouchable. And former President Trump, the leader of the big lie and fake voter fraud movement, has been granted impunity by the very justices he helped install on the court. So that begs the question, what will the next president get away with this newly established immunity? I know I've spoken, I know the hearing's gone long, and I appreciate the patience, but a few quick questions for Ms. McCord. With the limited time that I have left, I want to ask a few simple yes or no questions about hypothetical but not far-fetched scenarios. If a future president were to order the Department of Justice to cease investigating their spouse, their child, or themselves for alleged criminal conduct, would that be an official act?
It would appear that under the court's ruling, yes, that would be immune. Actually, even more than official act as core constitutional powers.
Because the president directs the executive branch. Scenario number two, if a future president were to direct the armed services to attack the home of a political rival, would that be an official act?
I think that is one of the questions the court leaves open for us. If his own...
The fact that it's not a clear no is the problem, because the president is the commander-in-chief. Like, Mr. Chair, I can go on and on with example after example that should alarm us and the American people. But I will conclude by just acknowledging this. It's particularly auspicious that this committee is meeting today to examine this wildly consequential and wildly unprecedented decision. 235 years to the day since the Supreme Court was established by an act of Congress. So, in closing, I'll just echo Justice Sotomayor's powerful words. Every president in our history has governed with the understanding shared by the American people that they could be held accountable for crimes committed while in office. And with that no longer the case, I share her fear for our democracy, and I stand firmly with the spirit of her dissent. Thank you, Mr. Chair.
Thank you, Senator Padilla, and thank you to the witnesses. We appreciate your being here today. The committee meeting stands adjourned.